Very quiet. So we might as well get started. Okay, we'll call to order the Grand Traverse County Board of Commissioners meeting for Wednesday, November 1st, 2017. If we could please stand for the pledge.
Of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call, please, Bonnie.
Johnson?
Here.
Klaus?
Here.
Wheelock?
Yes, ma'am.
Gorfulet?
Here.
Mayor?
Here.
Lathrop?
Yep.
Crawford?
Here. We have approval of the minutes. We have our minutes of October 18th, 2017, the regular session, and the minutes of October 25th, 2017, our study session on the budget.
I make the motion that we approve the minutes of October 18th, regular session, and the minutes of October 25th, study session.
Support.
Moved by Commissioner Lathrop, supported by Commissioner Klaus. Any discussion? All those in favor say aye.
Aye.
Any opposed? Okay, we'll stand approved. This is our first chance for public comment. Bonnie, will you read the rules, please?
Any person shall be permitted to address a meeting of the Board of Commissioners which is required to be open to the public under the provision of the Michigan Open Meetings Act. Public comment shall be carried out in accordance with the following board rules and procedures. Any person wishing to address the board shall state his or her name and address. No person shall be allowed to speak more than once on the same matter, excluding time needed to answer commissioners' questions, if any. The chairperson shall control the amount of time each person shall be allowed to speak, which shall not exceed 3 minutes. The chairperson may, at his or her discretion, extend the amount of time any person is allowed to speak. Public comment will be solicited during the 2 public comment periods noted in Rule 5.4, Order of Business. However, public comment will generally be received at any time during the meeting regarding a specific topic currently under discussion by the board. Members of the public wishing to comment should raise their hand or pass a note to the clerk in order to be recognized and shall not address the board until called upon by the chairperson.
Okay, thank you. Do we have anyone for first public comment this evening? Yes, ma'am. Step right up.
Good evening, Commissioners. My name is TJ Andrews. I'm an attorney on behalf of the Watershed Center, Grand Traverse Bay. Ahead of your meeting this evening, we emailed a packet which I understand may not have actually reached you in advance of your marathon meetings today. So I have distributed a copy of that ahead of the meeting. I hope you will at some point get a chance to look at it. I understand you have a lot of reading material. The Watershed Center is an organization which you may know advocates for water quality in Grand Traverse Bay, and we have a very strong interest in this county's soil erosion and sedimentation control office. We believe that is the office and its officers and inspectors are basically the front line when it comes to water quality protection in Grand Traverse County. This is also a county that's facing extreme development pressure, probably the most significant pressure in the state. Much of that development occurs in sensitive locations, near wetlands, along the shorelines, and it's a county whose prosperity is tied directly to our water quality. As a result, of any county in Michigan that should have a strong, well-supported, efficient soil erosion department, it should be ours. As you may know, historically, Grand Traverse County has had a stringent soil erosion sedimentation control ordinance, and I do want to focus my comments on the ordinance provision tonight. Our letter also addresses the move to environmental health. The historic events are beyond the scope of my few minutes up here, but a few years ago, the county decided to take a step off some provisions in that ordinance and to determine how best to do that, how to balance the water quality concerns that this county deserves at the same time ensuring efficient, effective government. When it comes to water quality enforcement, the county created an ad hoc committee. I was a member of that committee. Commissioner Klaus, Commissioner Lathrop were. It was a balanced committee. There were members from the development community. Elmers was represented. Engineers were represented. Mr. Cooney was part of that. We met for at least 6 meetings over the course of as many months. Each meeting was well engaged and debated, and the hours of work that went in ahead and after those meetings was also significant. And the result of that was a balanced ordinance. There's a draft of that ordinance in your package, and it's never been progressed beyond a unanimous to my understanding, approval by the whole prior commission, but through the Resource and Management, Asset Management Committee. At this point, I understand that you have in front of you a proposal to consider it, moving forward with it, or stepping further back to the Bear Part 91 ordinance. We believe this county deserves better than the bare minimum. We think the revised ordinance that you have in front of you represents a balanced approach. If you can't move forward with it, if I may just conclude
You can continue.
for 30
That's
seconds.
fine.
Thank you.
You're fine.
We would urge you to study this issue. This is a complex issue. It's got a lot of history, and it's a critical issue in this county when it comes to water quality protection. It deserves deliberate and studied action, and we hope that you will take that. Thank you for your time.
Okay, thank
May I ask a
you.
question?
Yeah, you can ask a question.
What's the Watershed Center's opinion on slope? 10 degrees or?
We believe that 10 degrees would be a better protection. The existing ordinance that's basically been decided to be stepped off of had 10%. The proposed revised ordinance covers 20%. We think that's far too permissive. A lot of runoff happens at far less than 20%. At the same time, we think we would love to see that provision rolled back, and we advocated strongly for it. We put a petition in front of the commission with 250 signatures that we gathered in a short amount of time sharing our view. We recognize that there are compromises as well, and we could live with the 20%, assuming that there is strong enforcement and the department has the resources it needs, and with the understanding that that might need to be revisited in the future.
Okay, any other questions? No. Okay, thank you. Anybody else for public comment at this time? Yes, sir.
My name's Bill Klaus. Did you want my address?
Sure,
5523 North Hannah Road, Kingsley, Michigan.
thank you.
I'm here to speak on the same matter. My opinion is that the county does not need its own soil erosion ordinance for the following reasons. In 1994, Michigan adopted NREPA. The Natural Resources and Environmental Protection Act, NREPA, Chapter 324, Part 91, governs soil erosion and sedimentation control issues. Part 91 specifically governs the movement of solid particulate matter from the land, whether suspended in water, wind, or gravity, at a site in which the earth is impacted by activities such as land development. The state of Michigan has promulgated a law pertaining to the enforcement and management of stormwater and management of soil erosion and water drainage under the Soil Erosion and Sedimentation Control Act and the Michigan Drain Code of 1956. We have 11 pages of law, Chapter 324, Part 91, and at least 103 pages of law in the Michigan Drain Code of 56. I just can't imagine that we need any more than that. If you turn the clock back a ways, when Warren Verhaeg and Virgil Thayer were the drain commissioners at that time, I just don't know what was wrong then. There was very little notoriety regarding any trouble. And if we could get back to Part 91, which is what we had when they were the drain commissioners governing these matters at that time, the state would step in and help us enforce Part 91. The items that the county may or may not add on top of Part 91 for their own soil erosion ordinance certainly would not be enforceable by the state. They would be on the county's back. The county has big budget trouble, and I just don't see that there's a good reason for the county to adopt its own soil erosion ordinance, which is going to require more staff, more burden on the residents of the county, the taxpayers. Those are my comments on the matter. Thank you.
Thank you.
Thank you.
Anybody else? No? Yes, ma'am.
Hello, my name is Lucille Hoffman. I live at 115 East 8th Street in Old Town, and I'm here tonight to talk about the senior bus. And I guess this has been a couple years in making, and I wanted to tell you, I just had my 88th birthday, so I take Beta almost every day, and it's wonderful. The drivers are kind. There's the Link bus is stretched to the limit as far as calling, and so I think the senior bus is going to be a great addition. There's several people I want to thank here, because Lucy would kind of call Jen every month or so and say, Jen, you know, are we going to get a senior bus? And she would go, you know, we're going to work on it. And if you need to talk to her about not reinventing the wheel, she knows all about the Grand Rapids system, and she would be a great asset. Thank you. Lori Wells, I don't think she's here tonight, but every time I'd go to the senior center, I'd say, Lori, you know, when are we going to get a senior bus? Because at my age, I really shouldn't be driving, and I gave it up. But I'm out and about to get fresh air and exercise and have lunch and take classes and volunteer. Cindy, who is part of the Council on Aging and comes to my house every 2 weeks, and I would talk to her about it. So when she would have a meeting for, you know, she would say, when are we going to get a senior bus? So Cindy is wonderful. The Commission on Aging is such an amazing organization where they're not a business. They have empathy, and the people that they hire have a heart. And they're kind of the eyes and the ears that if they come in and they know you because they've been, if something is wrong, they will go back and kind of contact family and all. So I just speak very highly. And Kristen Erickson from Parks and Rec, I saw her out at Interlochen about a year ago and asked her about a senior bus, and she said, that's a good idea. We don't have it in this year's budget, but I'll try. And so anyway, I wanted to thank you and thank them for finally, hopefully we're going to have it. Why do we need
You can continue.
why do we need a senior bus? With my vision and my handicap, the sidewalks are kind of in disrepair, and I know there's not a lot of money to take care of it, and kind of uneven services, have to cross busy streets, and I'm looking down, and shelters, there's not shelters everywhere, so in the snow and rain and no place to sit down. I can stand for about 10 or 15 minutes, but then this leg starts hurting. But thank you very much. I hope it passes because we really need it. Thank you.
Thank you. Anybody else? We'll have other opportunities during specific topics, so. Okay, we will move on to approving the agenda. Anybody have anything to add or any changes or anything to the agenda this evening?
Move we approve the agenda as presented. Support.
Moved by Commissioner Johnson, supported by Commissioner Klaus. Any discussion?
Oh,
Yes?
When did you want to add to the agenda the the item about the compensation committee?
That's in notices at the bottom.
Okay, okay.
That's, yeah, that doesn't need to be added.
All right.
It'll just be a notice at the end. Any other discussion? All those in favor say aye.
Aye.
Any opposed? Okay, we have an agenda as presented. Move on to the consent calendar. Bonnie, please.
The purpose of the consent calendar is to expedite business by grouping non-controversial items together to be dealt with by one commission motion without discussion. Any member of the commission, staff, or the public may ask that any item on the consent calendar be removed and placed elsewhere on the agenda for full discussion. Such requests will be automatically respected. If any item is not removed from the consent calendar, the action noted, receive and file or approval, is approved by a single commission action adopting the consent calendar. Receive and file. Number 1, Green Lake Township Annual Report regarding status of tax increment financing, interlock and DDA. Number 2, resolution in support of amending the Emergency Telephone Services Enabling Act, Alger County. Number 3, resolutions opposing reduction in federal funding for Great Lakes Restoration Initiative, Alger and Livingston counties. Number 4, Grand Traverse County Department of Health and Human Services minutes of June 27th. Number 5, Grand Traverse County Department of Health and Human Services minutes of July 25th. Number 6, Grand Traverse County Department of Health and Human Services minutes of August 22nd. Number 7, Northwestern Regional Airport Commission minutes of September 26th. Approvals. Number 1, District Court, Michigan Supreme Court Adult Drug Court Grant Contract. Number 2, District Court, Michigan Supreme Court Hybrid DWI Drug Court Grant Contract. Number 3, Health Department, Contract Renewal for Medical Director Michael Collins. Number 4, County Administrator, Appointments to Boards, EDC, and Pension Advisory Board.
Okay, does anybody have anything they want removed from the consent calendar and discussed elsewhere? Yes, Cheryl.
Number 2 and 3 from receive and file, and number,
A, 2, and, okay,
Yeah.
A, 2, and 3.
and number 3 from approvals.
The Health Department? Okay, anybody else? Anybody from the public or administration? Okay.
Move we approve the consent calendar with the items removed as previously stated.
Okay. There's support. Moved by Commissioner Johnson, supported by Commissioner Klaus. Any further discussion? All those in favor say aye.
Aye.
Any opposed? Okay, so we will move on and discuss those later. We have special orders of business. We have the Michigan Indigent Defense Council presentation with Janet Matthew. Welcome.
Good evening. Thank you for having me this evening. I know you've had a long day, so my intent is just to keep this basic, give you a basic framework of how the Michigan Indigent Defense Commission Act is structured, so that when you receive the plan that Ms. DeHaan has been working on and other folks within your community, hopefully on the 15th, that you'll have a framework to work with when looking at that. I also wanted to introduce myself and my colleague Marla McGowan. Marla has been with the MIDC since the very beginning. She is a guru. I've been working, my region is northern Michigan. I have a large region. I've been working with counties throughout the region. So I just want to make sure that you know who I am, that you know who Marla is, so that if you do have questions following this brief presentation, that you feel comfortable reaching out to us. And I will leave my contact information with Ms. Uppel so that you have the means to get a hold of me. So you're probably wondering why it is that we're here talking to you rather than talking to the courts, considering the fact that this has to do with indigent defense. The reason is because in last summer, the Michigan Supreme Court approved 4 standards that I'll get into in a moment. But they also, in that order, changed some of our enabling legislation to alleviate separation of powers concerns. In doing that, they moved our agency from the courts, from the judiciary, to the executive branch. So now the entities that will be submitting compliance plans are the funding unit. In other words, you guys. You're going to be presented with a plan to look at and ultimately decide whether what you want to submit to the plan to the commission for approval. How do you do that, considering the fact that obviously the courts have more expertise, institutional knowledge of how these courts work? Ms. DeHaan has been working very hard in talking to various stakeholders to make sure that she's able to put a plan together. We have a meeting coming up tomorrow with the group of stakeholders that we've reached out to make sure that we have a input from the defense bar, from the judges, from the administration, and also hopefully from you as well. So I'd like to invite you tomorrow, if you're interested and would like more information about this, please feel free to come to that meeting tomorrow at 10 a.m. I believe we're meeting in the conference room of the district court on the first floor. So if following this presentation there's something that you're concerned about or you have a question about or just want to find out more about what Grand Traverse specifically is doing, feel free to come to that meeting. The timeline that we're looking at for funding for this, and let me back up. So actually, the basic concept of this act is to alleviate the financial burden of indigent defense from the county and make it a state concern. Without getting into all the reasons that happened, the Sixth Amendment constitutional concerns, these programs throughout our state need more money, and the counties don't have it. So this act was enacted in order to alleviate that financial issue, and that burden for the counties is going to be paid for by the states now. What your county is going to be required to pay going forward is what's called the local share. The local share, and Jen is all over this, she's got it figured out, but in brief, what it is you take the average of what your county spent on indigent defense in fiscal years 2010, 11, 12, minus reimbursements divided by 3. Again, it's relatively simple, but there are nuanced issues with that equation, and Jen has managed to get that number for you. Going forward, that is the maximum that you'll have to pay, barring any statutory change. The benefit to that is that obviously a lot of counties are currently paying more for their indigent defense than they were in 10, 11, 12. So going forward, hopefully you'll actually be paying less than you are currently. It's one of the benefits of this act. Now, the standards, let me start here. So we have a big deadline coming up. You may or may not have heard about it. It's a big one. We've got a compliance plan in the works. We will present it to you on maybe Jen or Ms. Uppel, someone within the administration will present it to you for your approval at that point. It has to be submitted to our commission by the 20th, and that's statewide. So we're scrambling. Every county in the state is doing exactly what you are right now.
Of November?
Yes.
You got
Yes.
So it'll come back in 2 weeks.
Yes. So after that, there is a process by which our commission will look at, review these plans, and hopefully approve them within 60 days. If not, they'll come back to us. We'll have another 30 days. Hopefully, by the beginning of next year, we will have a plan approved. The next big part of this process is getting the appropriation from the state legislature to pay for this. As you could probably imagine, this is not exactly an inexpensive program. It's addressing a long-standing issue that hasn't been addressed for decades, and so there is controversy. Throughout my region, there's a lot of skepticism about whether the state is actually going to fund this or not. What I will tell you with that is I don't have a crystal ball. We've obviously been working with the state budget office, the governor's office, and the legislature to make sure that we're doing what we need to do to get passed. We will know next summer if the funding is going to come through for this. If it doesn't, none of this applies. The only time that these standards are going to be required is once the money is in the county's coffers. So I just want to let you know that, because with this plan that we're submitting on November 20th, the work that's going into it is beneficial. If it's not funded, none of the standards apply. Obviously, we all hope it will, but I just want to let you know that none of these standards or mandates are required if the funding doesn't come through. When it does, it will be presumably for fiscal year 2019, and it presumably will be distributed in October of 2018. At that point, then, we have 180 days to come into compliance to basically enact the plan that we've been putting together. Does that all make sense so far?
You bet.
All right. Talked about the local share. Do you have any questions on how that is calculated?
I don't have a question about that necessarily, but I would be curious to know what we expended in 2017 to date on indigent defense?
Oh, that's a good
Because I see some
question.
fairly significant numbers every month in our, we know what that number is?
So, 522,000.
So far this year, 522,000.
$522,876
Through which month? Or through today?
through IDI.
Along the same lines, I know that Jen gave this information to me, but do you remember what the local share was from that 3-year average?
No, we're still working on that.
We're still working on it. Okay, well, it's in the works. But,
Yeah.
so we'll be able to compare that number to the local share, so you'll see what hopefully, once we get the funding, you'll be saving on that.
Are you going to tell us what your recommendation is as far as which plan we're going to pursue?
We are working on that. And actually, one of the things that's infused into this statute is local control. I can advise you on what some of my other counties are doing. I can talk to you about that. One of the way we've been approaching it thus far is baby steps, that we're not going to make any wholesale changes. Maybe next year, once the appropriation has been dispersed, then we could proceed with more confidence in maybe making some bigger changes. But for now, and not just Grand Traverse, Antrim and Leelanau also are taking baby steps. But also, again, it's local control. So how you as a commission ultimately want to do it, that will be, and that's part of the reason I'm here, to make sure we're having this communication so that you don't end up with a plan on the 15th that you agree.
So I'm sure all of my fellow commissioners reviewed this with the same level of zeal as I do. I happen to be an attorney, so I'm kind of interested in the issue. But I know from the work that I do in Wexford County that they're looking at, they were talking anyway about establishing basically a prosecutor's office for criminal defense.
Yes.
So they would staff
Public
it with...
defender office, yeah.
Yeah, basically a public defender's office where they would have a full-time public defender and they'd have a couple other public defenders working with them, which seemed to me like a significant cost savings over the way that we're doing it, where we're paying almost $600,000 so far this year to individuals.
That is a great discussion, and Wexford Misaki are within my region. I've been helping them develop that plan. They're doing a regionalized defender's office. There are other options too, doing a hybrid office, and if you're available tomorrow at 10, I would love to have you there.
Well, I'm not, but that's why I wondered if you're steering us in a direction, if you're just throwing it all out there. I mean, what's the purpose of the plan at this point?
Right, so my purpose is just to provide you with the information, the administration with the information, so that we can go in the direction that you want. I don't, there are a lot of pros and cons with each plan. One of the realities that we face throughout the state is that if you do a defender's office, there often is very significant political pushback. Because if you do that, you're concentrating all the work into one office, and the reality of that is that attorneys who've been doing this work for a long time lose cases. Some counties, that's not an issue for. Other counties, it's more of a political problem. One thing I will mention is that, going forward, we are going to be submitting a plan every year. If we look at this plan a year from now and do some math, look at the outcomes of it, and decide that, a public defender's office might be the better way to go, we could take that approach a year from now. Correct, Marla? So we don't necessarily have to... What we do this year is we're not stuck with that. And the approach that Grand Traverse has thus far been taking, and I think Jen would back me up, we're still in the beginning of, not the beginning of it, it's well drafted, but it's not finalized yet. And that's part of the reason we're having this meeting tomorrow, to make sure that these discussions are ahead, and also so that we can talk you through the thought process that we've gone through in terms of getting to where we're at, if that makes any sense.
And when you get to that place, you'll have a number attached to that.
Right.
I hope the number's a lot less than $600,000.
I do too. And one thing that's worth mentioning, a defender's office actually can be very expensive, especially the startup cost to it. Part of the main idea with the MIDC is that any plan that we implement that costs more than your local share, that's going to be paid for by the state. So one of the reasons people are looking at doing a defender's office now when they haven't before is because
the state will pay for it.
The state will pay for it. And once, what I'm finding though, which is interesting, is that your point is well taken. In Alger County, where they're doing a hybrid defender office, managed assigned counsel system, where they have, well, I won't get into all the details, but what they're finding is that when you take out the startup costs, that it's actually a lot less money to run that program. granted
I
eligibility.
read your handout, it was very informative, thank you.
Good, I'm
Yeah, it was
glad to
very
hear
good.
that. Thank you. I would actually really love to talk to you more, especially with your background. It would be, I'd love to get your input on it, even if you can't be there tomorrow. Now, real quick, the first 4 standards that we're approaching, that we're working with on this compliance plan for November 20th are training and education. There's going to be some mandatory continuing legal education for attorneys who choose to do court-appointed work, paid for by the state, again. It's 12 hours for attorneys who have more than 2 years of experience, and there's a special provision for more hands-on training for attorneys who have less than 2 years of criminal defense experience. The second standard is the initial interview. We're requiring that attorneys meet with their incarcerated indigent clients within 3 business days.
You're so demanding.
Some people are really, they don't like that, but my response is always that, when clients come to me prior to my job here, their mama comes to me with a $10,000 retainer, the first thing I do is go to the jail and meet with the client, even if it's 8 p.m. on a Saturday. So, and also one of the things that's happening is that the sheriff's offices that have been encouraged to be in these stakeholder groups too, because this obviously impacts their workflow and there are resources available to help them with any additional work that they would need as a result of this. They love this idea because their population, the main stress that they're dealing with in their jails is that I can't talk to my lawyer. Where's my lawyer? I need to call my lawyer. I haven't met my lawyer. And so when we talk to the sheriffs about this plan, they're like, this is a great idea. So the basic concept of these standards is to create a sense of relationship between clients and their attorneys from the get-go to help alleviate a lot of the inefficiencies that exist in the court system as it stands. And I could talk all night about that, and I'll spare you. But we're seeing, for example, the number of cases that get resolved at very early stages is going up in the pilot programs we've been running. It's helpful for the prosecutor's office. The prosecutor knows who to talk to. He knows that at the prelim, the attorney will have met with the client, so when he offers a perfectly good plea deal that a client might otherwise say no to because they don't trust this guy that they just met, that there will a relationship will have already formed. So the prosecutor offers that deal, and the client can talk to the attorney and trust that attorney that what he's telling him is in his best interest, in the event that it is. The third standard is funding for experts and investigators. That's kind of self-explanatory. You guys have probably been on the hook in the past for expert fees that can be quite expensive in some of these cases that we get. The state is, anything beyond your local share, the state is now going to be providing. And part of the idea also is providing investigators for defense counsel. The prosecutors have the police. Criminal defense attorneys historically have had not that service, and there are ethical issues that can arise from investigating your own cases because you can accidentally make yourself a witness to your own case and then you're conflicted out. It can create problems. So providing resources for investigators, it also makes the system, again, more efficient. The cases are more thoroughly analyzed so that going in, the client knows and the attorney knows what the case is about. It resolves the cases that should be resolved more quickly, and then the cases that should be tried are tried and not just pled out because it's easier to do that. Fourth standard is counsel at first appearance, which is counsel generally, that means at arraignment. We're requiring counsel at all critical stages. Generally speaking, most counties have attorneys at critical stages, but for the arraignment. This new standard requires attorneys to be at the arraignment. Part of the benefit of that is, again, the prosecutor on certain types of cases, I believe you do sometimes written plea offers with the, anyway, it makes it more efficient because the defense attorney can decide, look at the information they have, it's a good stop, look at the basic flow of it. And what we find is, we ran a counsel at first appearance pilot program in Huron County. We had something like 23% more cases being resolved at the arraignment than there were previously. So there is money attached to that. You're going to have to pay attorneys more to do that because they probably have not been doing that before these standards come into play. They're going to get paid for it. That's the whole concept. And what I'm finding is that there's a lot of resistance from the defense bar initially at that idea because it's like more work. But then when we talk about the numbers that the state is looking at paying them for that, they're like, oh, can I do it all? Can I do all the arraignments all the time? Because that would be great. So again, that's part of the reason we're doing the work group tomorrow, to get everybody on board and make sure the defense attorneys also know what we're looking at, because as you might not surprise you, I do get a lot of the same questions a lot of time. And so, we've developed answers to that. I can answer questions. And again, if you are available at 10 tomorrow, I'd love to see you there. Or you can call me anytime. I think that might be all I've got for you. We do have another set of 4 standards that are currently in public comment phase. You can find those on our website. I encourage all of you to look at them and comment on them if you feel the need. We take public comment very seriously, and the public comment that we got on these first 4 standards was instrumental in saving us from some massive headaches at this stage of the game. So please, if you get a chance, take a look. I encouraged the judges at Region 4 conference to do the same, because we want to hear it. We want to hear it now. That can help us, again, alleviate a lot of problems down the road, and we take it very seriously. I also provided a handout for you guys. There's more information on our website. In fact, there is a ton of information on our website, so if you need help finding a specific document or you have questions about something specific, always feel free to reach out to me. All right.
Does anybody have any questions? Sunny?
Well, a couple things. One, periodically, as I recall, on multiple occasions, we've taken bids and established lists of court-appointed defense attorneys, that we are paying for. And there was always a price per hour, and there a price per arraignment, or whatever the situation was. Those numbers always seemed really high to me, but, I still work for a living for a lot lower
Consider
rate
the
than
overhead.
they do. So, and we have no...
More education.
Okay. You can't do my job either, so we'll leave it at that point. The bottom line is we have plenty of attorneys in this community, and, I guess moving forward with this, I'm more than happy. We've had, on multiple occasions, we've had the discussion about whether or not we should have a defense attorney's office similar to the prosecuting attorney's office over the years. I know that for a fact. I guess the one question, I always hate time crunches. When did this come to us in the first place? Is this a new thing that just came to us that we're now at a time
The
crunch?
Michigan Indigent Defense. Well, you guys aren't alone in where we're at right now. Jen has been working really, really hard on this. So while this might be new to you, don't worry. Under the surface, there's a lot of work that's been put into this. Right now, I will tell you that there are certain counties that have been, just the A students of their classes. They've been banging down my door for months. They've got their plan ready to go. Chippewa County was the first in the state to submit their plan, which I'm very proud of them for doing. Most counties, though, are still in the development phase. So you're not behind. And also the other thing is, because I've been working with counties throughout the state in developing these plans, we'll get it done. So again, it's kind of all over the board in terms of where counties are at, and you're not in any different position.
I just don't like to be in a position where I haven't seen a plan and I'm going to be asked to approve it in less than 3 weeks.
I completely understand that. Completely understand that.
And I hadn't heard of it even prior to this. So.
Yeah. I'm assuming that you said there's the meeting tomorrow morning. There will be other stakeholder meetings, though, over the next couple weeks?
We'll see how tomorrow goes.
Okay.
We sent out the draft last week, and I've received feedback from a couple of the stakeholders. I'm going to present that feedback tomorrow and see what kind of additional comments we get. I think it's important to note that the first 4 standards really don't require a change to our system. There's some compliance things and some reporting things. There are some changes that could potentially, if they're implemented and funded by the state, impact the prosecutor's office and the jail, as well as some remodeling things at the courthouse in terms of confidentiality and making sure that there's accessible spaces. But those would be implemented later on. We chose not to go through a huge assessment of actually changing the process because right now, from the feedback that I've received, what we have works for our judicial system, and I would yield to the judge and the prosecutor here today if there was a desire to change something on that. I think Janice said it very well that, they are the experts experts in this, and I'm certainly not going to propose something that's entirely or completely different than what currently exists when that is working well for them. So, well, the plan is very simple. The four standards are not overwhelming. If anything, I think if funded, it'll give us some financial relief because according to Judge Power, our fees that were paid for indigent defense or costs in the years that are requested were lower, and so we may see some savings from that if it were to be funded. The initial projections, just a rough number, and this is perhaps on the high end, but it could be $500,000 that it will cost the state in order to get us up to those standards to meet that for staffing and some additional expenses. So it's pretty significant across the state. I think the number you threw out in a meeting one time was it was going to cost like $40 million from the state to be able to fund the first 4 MIDC standards. So where the state gets those dollars from will be something interesting to watch.
And also, along with Jen's point, the Antrim and Leelanau counties, I've been working closely with them as well, and they're taking the same approach, which is a wait-and-see approach. If we're going to make a wholesale change, or the discussion has hinged around, let's see if we get this first appropriation, and then if we do, let's take a look at potentially doing a defender's office, because there has been some discussion about doing a regionalized defender's office, which obviously is a political decision that has to have a lot of discussion. And, kind of right away, one of the counties was like, no, I think we're going to just do our own thing for now. And this is happening throughout my region. There are areas that they're looking at down the road, regionalizing, forming a defender's office. But I think the collective consensus for Antrim, Leelanau, and the discussions we've had with Traverse has been like, let's take a wait-and-see approach and address these first 4 standards and then reopen for discussion in the next compliance planning year, particularly when we have a year's worth of data that we've collected from this first compliance planning year.
Are our senators and representatives members of that stakeholders group?
They have not been.
Because my guess is the state doesn't have the money to make this happen.
You are not alone in that sentiment. I promise you.
If you do not engage them in the discussion, you may be interviewing just exercise in futility.
Well, what
they're
I
in
will tell
session,
you on
so I
that-
doubt they're available tomorrow. So.
Well, 2 things. Marla, are you aware of any state reps or senators that have been involved in any throughout the state? Some former, yeah. So that is a great idea. That isn't something that, obviously, our office is communicating with the state budget internally. The question of funding, you are not alone in that concern, obviously. There are reasons that we believe it will happen, but, it is a significant, and the other thing is, the $40 million is a cost projection. The reality is when you infuse a statute with local control, that means local control, so the numbers that we're getting might potentially be more than that, and whether the legislature chooses to fund that, we hope they will. What I will tell you on that, though, is that there is no harm in putting together a plan and hoping for the best. There's no harm in that. The skepticism is not new. I get it all over my region, but I will tell you that the harm would be to assume they're not going to fund it, not submit a plan, or submit a plan that you just is thrown together just to submit something, and then all of a sudden it's funded, and the counties all over your region have all this new cash, and you don't. So,
Well, there's a penalty for not submitting a plan.
and there's a penalty
we have to submit a plan.
Correct. But as far as the conservative approach, again, Grand Traverse, the entire circuit is taking that approach, and if we decide to revisit that a year from now, that is open for discussion. So.
Regionalization probably fits here as well as it does anywhere because of the fact that the same 3 counties are in both our district and our circuit court.
Correct.
Not necessarily the case everywhere.
That's true.
Can I just address Sunny's comment earlier about, so the standards were originally passed in May. I reached out to Terry Quinn and Judge Power in June, and we agreed at that point to have a wait-and-see approach to see what other models other communities were coming up with so we didn't have to reinvent the horse. So we've been well aware of it. Now is the crunch time and the push time to move this through. So we're making progress on it.
So can I, just the reason I asked about meetings of stakeholders, if there are others beyond tomorrow, can you make sure that the commissioners know
Oh, absolutely.
about that? Thank you.
Great.
Okay?
So, and we will know, I mean, obviously the timeline is tight, but whether it's part of the idea of having the stakeholder meeting tomorrow is to get everybody in a room and have a discussion. Given the timeline, we'll see again how tomorrow goes, but I want you to know, feel free to reach out to me. If I don't answer my phone, it's because I'm in a meeting and I will call you right back. And there are a lot of meetings in my life right now, but I am always happy to be here if I can help. And if I'm not, no, I'm not.
Okay.
All right?
We all good?
Anything else?
Okay.
Thank
Thank
you
you
so
very
much.
much. Oh. Okay, we'll move on to the items removed from the consent calendar. I believe, Cheryl, those are all yours.
Yeah, sorry about that.
It's all right.
I can take 2 and 3 together.
Okay.
Basically, my concern with we seem to be kind of regularly getting these resolutions from other places asking us to join with them and make a statement with them. The one from the Great Lakes, it's number 3, the Alger Livingston Counties one. It makes a reference in its document that they want us to join in to the attached position paper prepared by the Livingston County Drain Commissioner. Well, we didn't receive the attached position paper, and so we are being asked to sign on to a position for which I do not know what the position is as presented in the position paper. It may be, kill all the alewives. I mean, I don't know what it is, okay? But the point is, I don't like to just take these things and go, yay, team, let's all jump on board because, gee, we're all about whatever. And I really, in my prior board experience at the college, we sort of had a policy that we wouldn't do that. We wouldn't jump on other boards' stuff. We would do our own, if we felt compelled by a particular issue. We would submit our own statement to the legislature, to whomever. But to just it's almost becoming routine that we're being asked to sign on to other people's positions. And, I don't want to be a poobah, but I'm not wild about it, especially when I don't have all the information. And I'd just as soon really not do it at all.
I think that's why we tend to receive and file them, not take action unless one of the commissioners has a specific interest and wants to, make a motion to
It's not really an
pass a
approval.
resolution
It's
of
just that we've
support.
received it. It's not really approving it
Then
or
why
saying.
are they giving it to us? I mean, what function
let
does
us
it
know.
serve besides making us?
It's just informational, really.
It's another communication that was sent.
That's always been my impression too, is
In
it's
their
just more
resolution?
fluff in the package that I don't need to see.
Well, I just soon not see it.
I'd
We got enough
rather
fluff.
work on the business at hand.
So would I.
But
I think we have enough in
So-
our own county.
Chris has brought it to my attention that at the end of the resolutions, which one, the Livingston one? I don't see it. Oh, because it's in their resolution, it says, "Be it finally resolved that copies of this resolution be transmitted to the governor, all senators, representatives, and the other 82 Michigan counties." So they're not asking for our support, they're asking for our recognition that we received it. I
Well,
get it.
could, as opposed to receiving the whole document, I read everything you give me, okay?
I know.
I feel that that's my responsibility. I don't want to read all this stuff, so could you simply provide us with a list of the ones that you've received? I mean, since we're not acting on it, since we're not voting on it, since,
I think we had this discussion before. and Bonnie
Actually,
has an
I
answer.
did bring that up, that the receive and file doesn't, all the things that are in there, you don't necessarily need to see. It's not done in a lot of counties. And you guys asked that when I suggested that.
okay,
So-
and I'm not asking that you eliminate things that are from our county. I want to see the report from the health department. I want to see those minutes of those
So
meetings.
we'll just tell Chris not to put any of these forwarded resolutions in there, and that's fine.
I mean, you could just have them
Just have a
available if you
list.
wanted to go look at
Yeah,
them.
they can be on the
just
list,
have a
but they don't
list?
need to be in the packet
Sounds
in
good
their
to me.
entirety.
Received I mean, just exactly
That's
like you
fine.
got it right now, and if we're interested in it, we could go look.
You can look at it.
Okay, so
Oh, sounds good.
I would move to receive and file number 2 and 3.
Okay.
Support.
Moved by Commissioner
sorry,
Gorfulet, supported by Commissioner
mean to be a
Johnson.
pain.
No,
No. Any
can't
further
help it.
discussion?
valid point.
All those in favor say aye.
Aye.
Any opposed? Okay. Number 3, Health
Okay.
Department.
Remind me why we don't bid this out.
here comes Wendy to do just that.
Because it's a specialty service provided by a physician that's required by state statute to have not only the MD and the DO, but also a Master's in Public Health or MSPH, and there's not that many out. This is his probably 7th or 8th renewal, and this will probably be his last term, and then we're doing succession planning. It would probably cost us more if we bid it out, to be honest. It averages out to be, not including the on-call time that he responds whenever we need him, to about $62 an hour.
Well, we're paying him $4,000 a month and change. So
Right,
it's
for
costing
16
us
hours a week.
$48,000, so that's way above our bid policy for things that we bid out. So, I mean, I don't know.
It's compliant with the bid policy as it exists now.
Because it's a personal service, specialty service contract.
Yes. Yeah.
You don't have to bid professional services.
I appreciate that you don't have to. We're looking at that, however, and I thought it was an appropriate time to bring it up. I know that Dr. Collins has had the contract for many, many, many years, and I'm sure he's done a fine job, and it's nothing against him.
Right.
But I think that we have a growing area where there are many, many, many physicians, and there might be more than Dr. Collins who would qualify for this position. So to simply say, MD, OD, public health, there could be 20 in the region that would be
Or
interested.
someone else who was willing to get a certification to fill the
That
job.
too. So I'm just saying,
I hope that's the case, because we're actually concerned that when he retires, we're not going to have anybody who's willing for that money.
I guess you won't know till you put it out
we'll put it
there.
out there.
But I'm just saying, to just sua sponte, run these people by again and again and again, nobody should expect that they're going to have a set, a for sure thing. I mean, it's nice if you can get those government contracts and they come rolling in every year, but,
There is a
having
significant
bid-
amount of on-the-job, when physicians practice medicine, they're practicing typically at the individual level, and so public health is population level, so it's a whole different perspective, and there's investment in all the different clinical programs we have that they have to oversee.
I read the job
So-
description. I see what they have to do, and I also know that he does this same work for Leelanau County, he does the same work for, I talked to a commissioner yesterday who said that he does their work. Benzie County,
Not as of 2 years ago. He did previously. It's Dr. Meyerson now, who does it for
well,
about
I
8
think
counties.
he does this full-time. He's not also a private practicing physician?
Nope, this is a 16-hour-a-week position. That's all he currently does right now. Previously, he did. Previously, he covered Benzie Leelanau District Health Department as well.
So he's heading towards retirement?
Yes.
This is kind of his retirement plan. Okay.
Okay. Do we have a motion to approve the contract renewal?
So moved.
I will move to approve the renewal of the medical contract for Michael Collins for 2018, but ask staff to make sure that we look at other options going forward. I think we're down to a point that we can't get a bid in place for now, but I'll approve the contract for 2018, but I would hope that by the end of 2018, we see some sort of a process by which we look at other options.
I'll second that.
Okay, moved by Commissioner Wheelock, seconded by Commissioner Mayer. Any other discussion?
Sorry, Bonnie, can you write that?
Did you have
fast?
something, Dan? If
No,
that's- if
I was
that's in
gonna
hand.
second
Okay. All right.
Jen has
Can we just, a point of clarification, Wendy, how, it's a 3-year contract that's being proposed? So,
It's a 3-year contract, yeah.
I thought you said he was retiring at the end of the year.
I said this would be his last contract.
Oh, see, I'm not happy with that.
I didn't catch
He didn't
there was a
understand that. He
3-year
thought it was a
contract either.
year.
So do you want to amend your motion, Sonny, or?
I would amend the motion to enter into the contract for 2018.
Can we do that?
And then we'll look at it moving forward from there.
And I'll change my second to his revision.
Well, he's leaving it the same way that it was. Can we do that or not?
It's the same motion, or it's the same approval of the contract, but it is only for calendar year 2018. It was not committing Guaranty County on behalf of 2019 and 2020.
Is that possible, or is that not?
Well, if he doesn't want the
Anything's
work, he doesn't
If he
have to
doesn't-
accept the
Nope.
If he
contract.
doesn't sign his side of the
Okay.
contract,
They'll
then we come back and
from
talk
us
about some other
you know,
option.
With that caveat, okay.
It's typically been a 3-year term, so that's...
Okay. Any further discussion? All those in favor say aye.
Aye.
Any opposed? Okay. Thank you. Okay, moving on to departmental items, we have soil erosion. We have 2 things to consider this evening. The first is transfer to environmental health as the enforcing office. We have Jean Dorenzi to talk to us about this.
Jean Dorenzi, Director of Community Development, and
Dan Thorell, Environmental Health Director.
And in your packet, on pages 70 through 72, gives a brief outline from 2015 to current on what has happened with the soil erosion program. And just briefly, in 2015, the DEQ did an audit of the soil erosion program and found some deficiencies in there. And in the letter that we received in January of 2016, identified that there was deficiencies and that they would do proceedings to put us onto probation. And the word proceeding is an important word because that doesn't mean that we're on probation. It means that they'll start the proceedings. So we have not been on probation since 2015. They just found deficiencies and would start that process. But since 2015, and what we tried to identify within the memo are the improvements that we've made to the program itself. And we looked at moving the part-time soil erosion inspectors to full-time. So we have 2 full-time inspectors. We looked at different components to really improve the enforcement and to improve the efficiency of the program itself. And we believe that we have complied with a lot of the components that are in the report and the audit findings that DEQ has. To continue on the improvement process and to maintain the efficiency, we are recommending, we being community development and environmental health, that the program be administered by the Environmental Health Department for effectiveness and the efficiency piece of that. And the efficiency, as we indicated, would be about 17%, because the field sanitarians would have mutual site visits that are there, so they can not just do septic and well inspections, they can also do soil erosion inspections. And the field sanitarians, they are efficient with, and they know the soil conditions and what, I'm sorry.
Environmental regulations and soil types and whatnot. I mean, that's doing something like soil erosion and environmental protection it makes sense to have it under environmental health. It's not a far stretch for us to go into that field as far as that goes. And there's about a handful of other health departments around the state that also do soil erosion duties, that have sanitarians do it. And kind of the thought was, right now we have about 2.5 FTEs doing field work, and with a couple additional sanitarians that we would hire, we could break the areas down to a smaller geographic area to be able to handle the additional workload in those areas for the soil erosion permits, and have less distance to travel while the sanitarian is out in the field in that particular area. It should be noted that 17% efficiency, explained a little bit about how that came about. We figured that about half of the soil erosion permits, a little less than half, 43%, we actually are on site as well from the Environmental Health Department, because not all soil erosion permits are for sites that get well septic permits. There's people build pole barns or commercial sites or even homes that are on sewer systems. So we're not there, at every single one of these sites. So looking at that, the 43% that we figured, these are estimates based on the numbers that we're looking at. Dealing with the AS400, so it's trying to get information out of that. It's not super easy. So looking at number of inspections, the best that we would come up with, we're out there for the initial site visit as a sanitarian if we're looking at a new construction. residential home, and we're there for the final inspection once the septic system is installed. Okay, soil erosion inspectors are there much more often, typically about 5 times. For the initial, the final, and then typically over the course of a home takes, realistically about 12 months to build these days. So they're there 3 other times. So that's how we came up with the efficiency rate. Just wanted to make sure you're clear about that.
So based on that, we are recommending that the county board identify environmental health as a designating enforcing officer for the soil erosion program. The county board, in Part 91, that it's your program that you have to enforce, so you have to identify who your designating officer is to enforce that program. With that, and also with environmental health, you'll have a budget item next week that will be presented to you on how we're going to fund that, and it's going to be a variety of sources to be able to fund. So it's not going to be self-sustaining. It hasn't meant to be self-sustaining, so there will be added costs that we'll have to have for that program as well. So that's the first thing.
Okay. Dan?
Make the motion that we assign the duties of soil erosion administration to the...
Environmental health?
Yes.
Support. Okay.
Can I comment on that?
Well, hold on. Moved by Commissioner Lathrop and supported by Commissioner Gorfulet. Yes, further discussion. Go ahead, Dan.
I think it's an excellent idea. Gene came in and rescued this program and did a beautiful job, and it needed it. They're performing well now, and the idea of cross-training, which we've talked about for this program for, 8 years, has never happened. Well, now it will. We're going to have people that are cross-trained. It's much more efficient, and people who are knowledgeable about soils and soil types, and they're there already. So this is a great collaboration. I think it will work beautifully, and it's done by other counties successfully this way, and I support it wholeheartedly.
Anybody else? Bob?
What's the rough cost estimate? That I'm sure you got a number in mind or something.
Probably going to be around $50,000 to $60,000. We're looking at increasing the fees as well, so it's going to be a cross component of it.
Sunny?
Well, I appreciate the fact that the sanitarians have soil knowledges and those kind of things. I think the statement that they're going to be there anyway is terribly overrated. Wells and septic systems go in when footings are going in. They aren't even close to the time that landscaping is done and final grade on construction sites. If you think that you're going to get this done when the sanitarians are there, you're not. It's just simply not. And I think Dan's probably right. It's going to take another 4 to 5 visits to finish the soil erosion inspections. And we have to remember that not all soil erosion inspections have to do with new construction. But one of the other things that we need to also recognize is, whether we're talking about this or the soil erosion ordinance with the slopes and all that kind of thing, we have a lot of construction that goes on that doesn't have an erosion problem. There's not a soils problem. There's not an erosion problem just because of the site and the way the process works. Those we can have a very minimal presence at. But if you think that by making this move, the sanitarians are going to take care of it when they're doing the well and septic inspection, you're just, at least in my opinion, you're wrong. From the job sites I spend time at, and lately that's a lot of them.
I like the aspect of having that back all at Lafreniere, to have the convenience if somebody's coming in, that part is not.
Yeah, I don't have a problem with that, and like I said, conceptually I agree with it, but I do not want you to think that because they're going to go there and do the well and septic, they're going to be able to cover this, because it's not going to happen.
Sunny, if I can add to that, we didn't say it was going to be a one-stop. That's why it's only 17%. But 50% of the permits that we have a well and septic too. So when they're there at the initial site visit, they can also do the site inspection for the soil erosion permit. So it saves that one stop. It saves at least one visit.
It saves the initial inspection.
Which is big. For a county government, that's...
Assuming that the contractor is actually ready at that point.
Typically they are.
Well, I'm hearing well guys right now telling them they'll be 2.5 to 3 months before they can set a well on a site because the backlog is that bad.
But you still have the efficiency of knowing the site initially, even with its soil erosion for the well and septic. So you've been at that site at least once when a new application comes in.
Dan?
Well, another thing is the proven quality of the people that are going to be handling this thing. I know Dan's work, and I know the health department's work. I know they'll do a great job, but they won't drop the ball like it's been dropped in the past. So that's another good reason.
Anybody else? Comments or questions? All those in favor say aye.
Aye.
Any opposed? Okay, that motion carries. We move on to the second part. Consideration of soil erosion and sedimentation control ordinance or Part 91 only. This is the tricky part.
This is the tricky part because we started this in...
Talk right into the, because I got a note that at home they can't hear you.
So in 2015, this is when we started the change in the ordinance. And since some of you are new since 2015, I felt it important to really step back and look at the ordinance. This is really just very high level. It's not getting into the detail. But the County Board of Commissioners can, as the two individuals that had under public comment, you can just enforce under Part 91. And it's basically two things. If it's within 500 feet of a lake or stream, or you disturb 1 acre of soil. The current ordinance that we are under and following is out of compliance. And it's out of compliance for a few reasons, but the main reason is that it has stormwater attached to it, and under Part 91, we don't enforce stormwater. Townships enforce stormwater. And some of the definitions are wrong, and how we turn over permits are wrong as well. So we knew in 2015 we needed to change the ordinance. So in 15, there was an ad hoc committee that was formed that looked at what the new proposed ordinance would be. So each ordinance, you still have the requirements under Part 91, but our ordinance requires several different components as well. And the proposed ordinance identifies, that's in your packet, has the slopes of 20% or greater. It's 500 feet of a regulated wetland. Instead of 100 feet, it's now 500 feet. And Group D soils, that is within the ordinance. It identifies what those soils are. I think it's on page 3 of the ordinance that identifies what type of soils it is. And within, instead of all drainage easements and drainage district, it's just within 500 feet of an open county drain. So those are the additional requirements that we as a community have said that we're going to implement for the water quality of our area. The reason that it stopped, the ad hoc committee, the members that I have found within the minutes of the county board was T.J. Andrews from the watershed, Gosling Zubek, Nick Agostinelli, and two county commissioners and our prosecuting attorney. They did meet on several occasions, and it came back to the Resource Management and Administration on December 9th, 2015. You approved it. Resource Management is a committee of the whole. They approved it, but there's no more steps that were needed. One, you had to have a public hearing. But before we could schedule that public hearing, we received a letter from DEQ in January of 2016. So the proceedings on the proposed ordinance basically stopped, because at that point, DEQ indicated, nope, we're going to wait, we're going to look at this and start fixing the deficiencies that we identified within the audit. We've talked to DEQ, prosecuting attorney Cooney, myself, and Dan have talked with DEQ, and they have said you can move forward with however you're going to enforce Part 91 and identify your enforcing agency too. So in the memo, I identified that there's also an administrative consent agreement that the prosecutor will come back after we negotiate, but we need to move forward with the program so we're in compliance. And this ordinance is a big part of being in compliance with Part 91. So we're asking to either implement just say Part 91, or the new proposed ordinance that the ad hoc committee has identified as being what is a good word? I'm sorry.
More restrictive.
More restrictive, but less restrictive than the original ordinance. It's the compromise that was reached with the ad hoc committee. Compromise.
So the next step, our choice
The next
is
step-
Part 91 or the sort of compromise, and then the next step is to schedule a public, if we wanted to maybe go with the compromise, we can't approve it, we have to have a public hearing first.
We have to have a public hearing. DEQ still needs to approve it, and their process is the Soil Conservation District would need time to review it as well. The ad hoc committee really worked closely with DEQ. They've already commented on that. The ordinance that is within your packet, we believe, complies with all of their requirements. So now it's time for the board to look at that and decide, how do you want to proceed?
Don?
Gene, if we did adopt Part 91, the state wouldn't have to do any reviews, or the DEQ, or would they?
I'm going to defer to Bob, and he will correct me if I am wrong, but if you're Part 91, no ordinance.
And do you know what percentage of permits would not have been issued if we would have just used Part 91?
I think it was 37% that I
There's a
identified
number in
within my
there.
memo.
Oh, okay.
Yeah, 37.79%.
Did you want Bob to answer the first one?
It would probably still make sense to have an ordinance, because you have to still include penalty provisions, administrative provisions, fees, those types of things. You could do it by resolution, but I think probably the most sense is to have some type of an ordinance, even if you were to go to just Part 91 requirements. And just for the record, I was the attorney, not one of the members of the committee, so I wasn't one of the stakeholders in that committee, and it seems to me there were more members than that.
Dan?
Just want the public to know, and new board members to know, that a whole lot of work went into this new ordinance. And it wasn't easy. We duked it out, because we have people that are tree hugger types, and we have people that are not, and trying to blend everybody and get something that, I guess nobody was actually happy, but it came out as a pretty darn good ordinance. And I have to applaud Bob. He basically wrote the thing in a beautiful way. It was a lot of work that he did. This is a pretty sophisticated document, and I don't know how many pages our current one is. It's about this thick, and we've got this ordinance down to, I think, 17 pages. I mean, it's not onerous. So, and a lot of good minds went into putting this together. I just want you to know, it wasn't easy, and it's a quality document.
Anybody else? Sunny?
Well, I think, I'm struggling a little bit here with the procedure because, I absolutely agree with you, Dan. This is a very good document. I believe that the existing ordinance for Grand Traverse County is way too restrictive. I think it is very burdensome on any developer or builder that's trying to do anything in Grand Traverse County. Tree huggers or otherwise, we're very involved in drafting that ordinance and getting it adopted. I, along with a lot of other people, thought it was too restrictive at the time, but it still passed. The problems that I'm seeing with this is, first and foremost, that is the ordinance that's in place. So technically, that is the ordinance that we should be enforcing. Now, I do know that there are components in that ordinance that were deemed to be truly illegal, and one of those was the stormwater portion, which was put back on the townships, and at least for most of the townships that I'm involved with, they would just as soon not have it be part of the townships. They thought the county was doing just fine dealing with it, but they don't have the expertise, they don't have the ability to monitor it either, so. But, I'm not exactly familiar with how this ordinance drafts, but I've been involved in the solid waste through the DEQ on a few occasions, and I know that you have to hold the public hearing, and the DEQ has to approve it before you can hold your second public hearing and adopt it. The problem is I've got a notice from the DEQ that they will not approve any change to the ordinance until we're off probation.
We're not on probation.
Yeah, I believe it says we just started probation. We're just starting probation.
We didn't sign that. We didn't. Right, Jean?
Correct. Sunny, we received an administrative consent agreement in May of 2016. Until we sign that, that is when probation starts. We have not signed anything. Nothing has come back to this board.
So we have not signed the agreement that says we're on probation yet. So how does the DEQ feel about that?
Well, they're happy about it. My
understanding was they deemed that we had done something wrong, and thereby we were going to be put on probation. At least from my perspective, when I read those initial letters, I thought that meant we were on probation then. Apparently, 2 years later, we still haven't been put on probation yet, and I'm pretty sure that the judges won't allow that to happen in their courts, and I can't imagine that the DEQ did. But.
We are not on probation, correct, Jean?
Correct.
Okay.
I got to ask then, how long can we refuse to sign?
So we run around and we change the ordinance, we change the rules by which we play by, and then we sign the thing, and then we're on probation, and then we get them to approve that, and then we sign the document, and we get put on probation where they won't allow us to change anything for 2 years.
Bob has stepped up to give us an answer.
Well, I think Commissioner Wheelock raises a good point. We certainly thought that we were on probation until we received the communication May of this year. And anyway, we are in negotiations with DEQ over the proposed administrative consent order, and that's about all I can say about that because it is negotiations.
So if we were to change our ordinance prior to the entry of this administrative order, would they accept and respect that or not?
Well, I do think that might be a prudent course of action. It will take some time to schedule public hearings, and there's a 90-day review by DEQ. I can't imagine that they're not going to accept the ordinance as revised because we received that letter back in, I want to say, March of 2016, pointing out that there had been a revision of Part 91 that affected the ordinance, so we made those changes. Changes to the Health Department, which DEQ, I think I can say, has agreed that as long as our Health Department gets certified, then they're fine with moving it to the Health Department. They do have to approve the enforcing agency. And a few other housekeeping matters that they pointed out. And I'm sure T.J. Andrews has gone through that with a fine-tooth comb. And I should say that she had a whole lot to do with drafting the current revision that you're looking at least as much as I did. So anyway, that's where we're at with the ACO, and I do think it would be fine to start the process of asking for the public's approval, or public comment at least, to move the process along. DEQ would have to accept the ordinance for review, even with the ACO issue out there.
For purposes of discussion, can I make a motion?
I don't think we need a motion. Do we need a motion to have it move forward?
Yes?
Okay, yes, and then Tom, and then Dan. Go
And my
ahead, make your
motion is that we would begin the public hearing process for purposes of considering the proposed ordinance change.
Okay.
Support.
So moved by Commissioner Gorfulet, supported by Commissioner Johnson. Tom, you had a comment?
Well, that's about what I was going to say, is that it's, I'm still understanding this. It's pretty complicated for me. I am a tree hugger. Thanks, Dan,
I
for
didn't say
bringing
it
it up.
against tree
What did you say
huggers.
about the tree
Oh,
huggers?
wait a minute, I didn't say it was against tree huggers. I said that we took into account both tree huggers and the non-tree huggers.
No, I think
All
it's
right.
it's humorous to say it, but
But
it is
not to say any jokes.
it is very important, and I think a public hearing is the way we should handle something like this. I think that's how to do it, so.
Dan, did you have a comment, and then Bob?
The comment I think Bob already made, but I'd like to reinforce it, is throughout this process, it wasn't short. It seems to me that you were in contact with the DEQ quite a few times and revising what's already there. Am I correct?
Yeah, I was surprised to receive so many comments back from DEQ. Part of it was the change in the law, but I think most of it was just new eyes at DEQ looking at the document. Because, yeah, I was in constant communication with DEQ about all of the revisions that we made, and they were being approved. And
Which makes me think that it's going to be a pretty good document, because they were holding your hand and you were holding theirs the whole damn time.
there were a lot of
Yeah.
eyes on this one, yes.
Okay. Do you have a comment? Or- Yes.
Yeah, my comment is I still believe we should just be working with Part 91, which is what I was pushing for during the ordinance review, but we've got the proposed ordinance in front of us, so.
Okay, well, we'll go to public hearing. So Sunny,
I
and then
guess
we'll vote.
the only comment that I would make is I think with the revised ordinance and with a set program by which we're going to monitor and enforce that ordinance, in a distinct pattern, if you will, or chain of command by which we're going to do that, maybe with a little luck, DEQ won't put us on probation for 2 years. I don't
Maybe they'll
know
take it
that,
back.
but, the thing about it is, if we show them up front that we've made the change to the ordinance, that we've put in place the steps by which we're going to do a better job of monitoring and enforcing the ordinance, perhaps, the hand slapping won't be quite as hard, or the spanking won't be as much fun.
I've got another question.
Yes, Dan.
Sorry to belabor this.
No, it's okay.
If we just did Part 91, would we still require a public input? Okay,
That's by default, Part 91.
okay, gotcha.
The thing about it is, we're still changing a county ordinance. Whether we're talking about the existing ordinance, whether we're going to an amended ordinance, or whether we're going to Part 91, we're still changing the existing county ordinance, so I believe we still have to go through a public process. Is that right, Bob?
Maybe?
Well, I think if you were going to consider going to a straight Part 91 ordinance, you would probably want to have some
Still.
public hearing on this. I think we've only had this out on the agenda for about 10 days. So, that would be a major change in direction.
Well, you'd have to vacate an existing county ordinance. There would have to be a public process by which to do that also.
Okay, all those in favor say aye.
Aye.
Any opposed?
No.
Roll call, please, Bonnie.
want to get this straight. So the motion is to begin the public hearing process to move forward with the revised ordinance?
Yes.
Okay.
Proposed
The
ordinance.
proposed ordinance is how it's written on the
Revised
sheet.
proposed ordinance. Okay. Klaus?
No.
Wheelock?
Yes.
Gorfulet?
Yes.
Mayor?
Yes.
Lathrop?
Yes.
Johnson?
Yes.
Crawford?
Yes. Okay, motion still passes. Okay, thank you very much. We are going to move on. What did I do with my... Commission on Aging. We have the COAST program. Yes, are you going to go first, or Kelly, or?
I am, actually. I'm going to start. I want to introduce our new Commission on Aging Director, Cindy Kinlan, who's here. She's been here a week and a half, actually. And
Can she
so-
say hello at the podium so the people at home can see her?
Yeah, do you want to step up?
Because otherwise they can't. Thank you.
Hello.
Oh.
I'm very happy to be here. I've got a great staff who are very dedicated to their clients and their work, so we've got a lot of exciting things going.
Move it down. so we can
Microphone.
hear you.
Sorry.
There you go. It's up so high.
So we've got a lot of exciting things coming up, along with our bus and our new electronic health record that I hope you approve tonight, amongst some other things. So good continuing education for the staff and everything, and they're really excited. So I'm very happy to be here.
Thank you.
Happy to work with
Welcome.
Thank you.
Welcome, Cindy.
And then also here tonight is Kelly Dunham, the CEO of Beta, and Alan Vanderpass, who's the mobility manager. And I think Lucy said it best when she said that this has been something that's been an ongoing conversation for a couple of years. And so what we've done in the past few months is met together and are proposing a 90-day pilot program for a dedicated COAST bus. It's the Commission on Aging Senior Transit. Staff brainstormed and came up with the name and voted on it. And so we're proposing a 90-day program. Do you want to show a couple of the slides?
Yeah, what do I need to do, though, to get that?
Just clap your hands, we got the clap right here.
Bonnie will help you.
We currently offer, just as a matter of background,
Should be on, but...
we offer discounted Beta passes, and we would, this would be a dedicated bus that would be free of charge and operate on this 90-day pilot on Mondays and Wednesdays as a starting point. If demand were to exceed that and those days and hours that it's available, we would certainly look to expand the service. We've gotten a lot of positive feedback from staff, a lot of positive feedback from clients who are already calling to schedule their first ride, and so they're very excited about this, and the staff has been talking about it with clients, and I think we'll get a positive feedback.
Yeah, thank you, Jen. Again, I'm Kelly Dunham, I'm the director of Beta, and just here to give you a little bit of education on the upcoming proposed COAST partnership between Beta and the Commission on Aging. High-level overview, it is a contracted service from the COA to Beta. Will operate, as Jen mentioned, in this pilot phase, 2 days a week, Mondays and Wednesdays, from 8 to 5, be available on a door-to-door basis, reservations to be made in advance and awarded on a first-come, first-served basis. All of our vehicles, are equipped with handicap-accessible lifts. We're very excited for the opportunity to better serve members of the COA. It feels like a great partnership between two public service agencies, and I think it's really going to fill a void. Beta tries to be all things to all people, and that's not always possible in our general service. So to have dedicated service available and provided by the COA seems like a real win-win. So this is a picture of what the bus will look like. It will be branded with COAST and used to the extent possible. Occasionally we have to pull a bus off for service and swap out a different one, but this will be the primary bus serving on the service. And so I'm here to answer any questions about the proposed COAST program.
Tom, and then Dan.
What's the age for a senior?
The Commission on Aging, the ballot language defines it as 60 and over.
Why do you have to be a member of COA in order to be able to take the senior bus?
Because we're utilizing millage dollars from the Commission on Aging to fund the program.
Part of your argument was that those are dollars that are paid by taxpayers, and that's, so anybody who's a taxpayer and is over 60 ought to be able to ride it, shouldn't they? Because they're paying with their tax dollars.
Well, the intent of the dedicated millage through the Commission on Aging is to provide those in-home services to help seniors stay in their home. And so by ensuring that they are a Commission on Aging individual who's registered with the Commission on Aging, we can guarantee that those dollars are going towards that purpose with the intent of helping seniors stay in their home.
But this is for a bus, which isn't to stay in their home, this is to take the bus.
Transportation is absolutely one of the greatest needs that our seniors have, whether it's going to the grocery store, moving around town for social experiences,
Sure.
going to doctor's offices and doctor's
Sure.
visits. It's one of the largest needs that we hear that help seniors to stay in their home.
Well, and interestingly, the lady who spoke said she takes the bus every day almost. So how is it going to be different when she has a dedicated bus that we're going to be spending all this money on?
So right now, she competes.
Well, let's let Kelly answer first. We'll let Kelly in,
So right now, Lucy competes with everyone that is trying to use the bus, with the general public. And so she is in the first come, first serve queue with everyone. So the COA, which has received millage support to provide services to the seniors in the area, has come to Beta requesting assistance in meeting additional transportation needs solely for the seniors in our area that are registered with the COA. So this provides more access. They still have access to all of our general service, as does everyone.
And currently, do seniors have the ability to call and get a ride?
They do, on a first-come, first-served basis.
Which is exactly what this is, because if I read the contract, it says it's on a first-come, first-served basis.
Correct, but this would be an additional bus available just to COA members during those times and days of the week, in addition to all of the regular service that's available today.
Which we're not paying extra for, we're just
Right.
paying extra for this bus. So
Right.
if you have a rider out in Fife Lake who wants a ride and they call and ask for rides, so this dedicated bus drives out to Fife Lake to get that person, bring them back into Traverse, figuring that's probably round trip at least an hour, at least.
absolutely. Please, you have to step up to the podium, though, so that everybody at home can hear you.
It's also a door-to-door service, which for a lot of the seniors who really need this, makes a huge difference.
But don't we also have the ability to provide door-to-door through other vouchers? Don't we have taxis? I know we just paid a bill last month that was a taxi bill for door-to-door service for clients of COA.
Yeah, I think Jen can answer this. There's been a lot of problems and issues with that system.
The voucher program lacks in tracking and in efficiencies. It's still, we're not proposing any changes to that as of now, but depending on how well this takes off and runs, this may be an alternative that's actually cheaper and better for our COA clients, depending upon their needs and preferences.
Well, I've just been crunching the numbers, and I just don't see how it's more efficient. I understand that we have a lot of money because of the generosity of the taxpayers to give us a big chunk of money for COA, but I'm just, I'm looking at 3 months at $8,475 for the initial blast, and I'm sure then you'll come back and you'll want to continue it. And I'm wondering if you want to alter your numbers at all, because I got some information that the number of clients that you allege have been served are pretty significantly inflated, and that actually these are probably not unduplicated numbers. They are people who have taken advantage of the services over and over again.
It's clients that have purchased passes, yes. So it could be the same client, yeah. The COA, again, this is a challenge that we have with our data system. They count things, 15 different ways, the numbers change, and so, one of the things that will help with our electronic health records and our tracking program will be some consistencies there, so.
Is it better that less people use it more, or more people use it less? I'm not sure.
No, that isn't the analysis. The analysis is what the cost is. So if we had so far this year, we've had 223 clients purchasing transportation vouchers. 129 were beta passes, and 89 were vouchers and beta passes. That's 294 people, or that's 263 people. 263 people divided by 8,000, do the math. It's a pretty expensive ride for 3 months. So, if we want to encourage spending that money with no contribution from the seniors, even though the seniors are capable of buying reduced rate vouchers and reduced rate whatever, then I say we jump on this. But it's going to then be the next 3 months, and the next 3 months, and the next 3 months, which is going to add up to about $25,000 a year, and then we're probably going to want to add another bus, which will then be $50,000 a year, and then we're going to want to make it 5 days. I mean, we can do this. We can do this all day long. The question is there really the need for it when we have access to Beta buses that are all handicap accessible, that they can call and schedule a ride, that run routinely,
I think there is one additional distinction between this service versus our regular service, which will particularly benefit the senior population. And that is when we have a contracted service bus, we don't have to adhere to the same level of detail with our no-show policy, with the door-to-door service versus curb-to-curb, where when you're trying to be all things to all people, it's very important that, we're picking them up, we're dropping them off, we're not waiting extended periods of time, we're not having the driver get out of the bus and spend a lot of time helping passengers with grocery bags, and the seniors need an added level of support. And one way to accomplish that is through contracted service, where it's not about mass transit as much as it is in meeting the needs that we've been contracted to meet.
Another issue too is the vouchers. I'm really sure that really the appropriate people are using the vouchers and they're not being given other people. So that is very difficult to control.
So Ron, and then Bob, and then Tom.
So, Cheryl, the 263 people that you mentioned, is that that's how many trips? Or is that how many people are actually buying vouchers, maybe going on, taking 10 trips each or 15 trips each?
The numbers that I was given said that this year to date, 223 clients have purchased transportation vouchers. 129 of those were Beta passes, and 89 of those were vouchers and Beta passes. So I believe that the vouchers are like a dollar amount that you purchase that you can use.
Okay, so really
263 people.
Right, that it's serving and...
That we're serving, that we're looking at, and presumably, I mean, I'm anticipating that the numbers will increase if all of a sudden we're going to start offering free bus rides. We're probably going to get more people, okay? They're not going to have to buy a voucher. They're going to get it for free, okay? And so if you give something away, chances are you're going to get more, and I would almost guess we're going to add another bus or two.
Or at least another day.
Or another day or two. And that's fine, if that's where we want to spend the money. I mean, that's fine. But let's put it out there.
What I was going to say is we voted, I think it was 4-3, to give them back, was it 700,000 or whatever?
750.
So they've got such a surplus that, I mean, at some point, we gave it back to them with no plan. So they've come with the plan at least to use some of it. So, we can nickel and dime it to death, but the fact is we gave them a lot of money back that the taxpayers have spent over and above what they really needed, for any reserve fund. So, I mean, I say let's try the pilot program and see what happens. If it does get out of hand, then yeah, we cancel it,
What do you think about only COA members being allowed to use it, though? What about all the other seniors in the community? What's it cost to be a COA member?
Absolutely nothing. It's it's a phone call.
So
You have to be a registered client, don't you?
No, for the transportation program, you just have to provide a proof of residency and your age, and those are the two factors that would then, qualify you as a COA client for the transportation program, and that's correct.
I think if you come out of county, there's a cost, right? Out of the county.
But we're not going out of county.
We wouldn't be going out of the county.
But I mean, if you want to join the COA and you're out of county, there's a cost, I believe, for that. I thought there was.
No, I don't believe so. I've never heard that.
Tom was next for comment, and then Dan.
Well, if somebody's not currently a COA member and they want to use the bus, I think you should make it really clear to the public and through the media that it's simple to become a COA client, because then I think you should offer it, essentially tell everybody who's a senior citizen or permanently disabled that they can ride for free on Mondays and Wednesdays between certain hours, with the caveat that they have to just
Make the call.
register by a phone call with COA. Just show them how simple it is. But just to say that it's to look at it as it's just the current people that COA is serving, I think sort of misses it for me. And I think you're going to have a hard time with one bus providing good timely service if you get a lot of calls and they're not all, evened out nicely.
Just to make that very clear.
Yeah. So, I mean, I think, for all the money you're going to spend on the wrap, I would spend it on publicity to tell the public what it's really about, because I think the wrap is not necessary, really.
Dan?
Well, I may be prejudiced in this, I am the chair of Beta, and
Good disclaimer, Dan. Thanks, sir.
so, but that lets me have a closer peek at the excellent service Beta gives, and the excellent way they keep track of things and keep constantly improving. I hope we do have a bunch of people. I can't think of a better way to spend our money on, most of all in life, I'm a physician and surgeon, and being able to provide this type of service to these people, I have people that it costs them an arm and a leg, and to get to my office just to see me, they have to hire people, they have to count on their relatives. It's a big, hard thing. So if we can, as a community, I think this is a perfect collaboration between two public entities. How much better could we do than this? So I as a physician and as a board member, I think this is a wonderful idea, and I hope it does get great big and helps a bunch of people.
Would you like to make the motion?
Could I?
Go.
Am I allowed to do that?
You are.
Let's see, now, I'd like to make the motion that we do allow the COAST program using Beta and COA. Is that good enough?
Support.
Okay. Moved by Commissioner Lathrop, supported by Commissioner Klaus. Additional discussion, Sonny?
I have a couple issues. Number one, I think it's very important that we make note that this service is available to every senior in Grand Traverse County, every senior resident in Grand Traverse County. Because I know a lot of seniors who would certainly be eligible to use it or would want to use it that are not currently clients per se of the Commission on Aging. We have a lot of seniors in our community that are not COA clients, but yet this service may be a great benefit to them. How many people does this bus seat? 20?
18.
I was close. No, I'm trying to figure out how efficiency can develop when I take a 20-passenger bus and I go and provide door-to-door service. That doesn't seem to, equate to me. I have had a number of people tell me that the reason the Beta has went to all these wraps on the buses is because you can't see how many people are in it. And I'm not sure that I can disagree with that either. I guess if we do this as a pilot program, what I would like to do is try to figure out some way to track how many riders you have, and also how many individuals that you have.
Unduplicated headcount.
Because the long and the short of it is, if they pick, Jane Smith up at the end of my road and take her down to Thurlby Clinic and drop her off for a doctor's appointment, and then they go back there a half an hour later and pick her up and take her back home, that's 2 riders.
Unduplicated headcount.
Because
Those can both be reported.
So I was going to say,
What's
are there
that?
measurements
Those
in
will both
place?
be measured and reported.
they will both be reported, so it's 2 rides. That's my point.
No, we
have
will be collecting data on both of those
We
fronts.
have to collect it based on head counts. Back a few years ago, quite a few years ago now, when I was still at Long Lake Township, we had a duplex behind the township hall that was operating a Head Start system. And Beta was transporting 28 kids to that Head Start program every morning, picking them up every afternoon and taking them home 5 days a week. You can't imagine how many riders we had in Long Lake Township with Beta was being used. but it was the same 28 kids twice a day, 5 days a week. So we have to figure out a way, in order to justify any of these programs, we have to track them based on how many true riders we have, and that's unduplicated.
We will be tracking them.
We have to. Other than that,
I'll tell you
I
that.
will support the idea of doing a 3-month pilot, but I want to see real numbers of how many of the 90,000 residents of Grand Traverse County actually in fact use it.
That's much easier to track on a demand response service than it is on our fixed route service, which we don't have the ability to track. So sometimes you get reports from, a loop bus where we can't break it down to individual rider. That's not true on a service like this. We will have rides reserved in advance. Every rider will have a profile, and those are easily attainable reports.
Cheryl?
Well, just to make it really out there.
Really?
Yep, I really think that you ought to seriously consider coming up with some sort of a card that can be issued to any senior who asks for one that will allow them to ride any Beta bus they want under this program, because this program cannot meet the need as you're laying it out there. You don't have the numbers, you don't have the bus. So why can't Lucy get a card and she can get on the bus any day of the week that she wants through this program, and COA will pay for it. And if she needs the special door-to-door, she can do that too. But my point is, we already have a gajillion buses. They're already, you said all of them are outfitted with lifts for chairs, for handicapped, whatever. Get every senior who's over 60 and qualified a card and let them ride Beta anytime they want. I mean, isn't that the logical conclusion of where we're going? So why don't we just go there right away?
I think Miss Lucy would like to say
My
something.
doctor's
So we'll
appointment's
let,
on Tuesday now.
you can come on up to the
That's right. I
podium.
mean, what if your doctor's appointment is on Tuesday and Friday,
Okay,
not
hold
Monday
on.
and Wednesday?
Come on up. You can come up and, yes. Let us know what you think, please.
I just want to clarify, I do probably ride the bus every day. It's getting more difficult, especially when it rains and snows, and there are several buses. There's the Link bus that you can call, and then there's the other one that you have to walk to the bus stop and different bus stops. That's getting almost that I can't do that anymore. And the Link bus, because Beta's wonderful, but they're so stretched. They don't have enough Link buses, so if I call and say, Oriana's is one of my favorite places, and it's 5 blocks from my place. I can't walk there anymore because of the sidewalks and with my handicap. If I call Link, they might say, well, let me look at the time frame, and then I adjust to that. But then they'll say, well, for some things, you should call a week before, because they're stretched, they're trying, and that's why we need the senior bus it will be like a Link, but it won't be so crowded and so stretched, and so that's what I wanted
But it will
you to
only
know.
handle 18 people. So if you're one of the 18 every week, there's only 17 other seniors that are going to have that service available to them. So I'm suggesting there might be a whole bunch of seniors who aren't situated like you who would benefit from free bus rides. So why don't we just give it to them?
Well,
Let's figure out how to do that, because
Well,
there's all these
we're not
buses
gonna
that seniors are
argue back
riding
and
on.
forth, and we're gonna, yeah.
We got a motion doing.
But just
We do have a motion on the
clarifying
floor,
that there
yeah.
are several buses I'm getting where
Understood.
I can't take the regular
Understood.
bus anymore
Yep.
because of my handicap. And when I call Link, they they can't take me.
Yep.
And they'll say, well, call a week before. Well, I don't know a week before.
Well, that's what this bus will be too, Lucy.
Well, okay.
We'll see. Thank
Okay.
you, though. But that's
Thank you.
the clarification.
Okay.
Yes, there's two different buses.
Thank you.
One other question for Kelly.
Yes.
What is a $525 mobile billboard fee?
The advertising, is it the wrap itself? Which
No, that's
component?
$900.
That's different.
We're spending $930 for a Coast Wrap $256 for a design fee and a $525 mobile billboard fee.
So that would be the
I
three...
can even understand the design fee and the wrap fee, but I can't figure out what the mobile
You want it to
billboard
move,
fee
don't you?
So that would be a 3 months of the reduced fee, which I believe was offered to the COA at $175 a month for advertising the space on the side of a vehicle, which we sell advertising on the sides of our vehicles.
Okay, so the COA is going to pay, or the program is going to pay to have the bus wrapped, they're going to pay for the design, plus they're going to pay Beta $525 for you to drive around town with the Coast sign on the side of it?
That's correct.
Boy, that's a great deal if you can get it.
Okay.
And then every month thereafter would be $175 to continue that?
That is reduced from the normal rate of $225 a month for the advertising on the side of a bus.
Well, how about a friendly amendment to the motion? I'd like to propose that we not pay for a wrap and advertising on the side of the bus, since it's one bus out of the fleet. It's a pretty hefty monthly hit for one bus.
It's up to the motion maker. Before you consider that, this is just, hold on, this is just a pilot program.
Yeah.
So it's only 3 months.
Yeah.
And they have said that they're going to, have metrics and be able to come back to us and tell us how it's doing. So, in my opinion,
We will have already spent the $1,000 on the wrap.
we will, but I don't know,
Yeah,
to
and then
kind of pick it apart, it's up to you.
It's just part of the branding.
I'm going to keep my motion. I think that rather than rewrite the Bible, we've got two professionals that have done a great job on this, and it's just a beginning program. We'll let them gather the numbers, do their good job, and see what happens in time. So I'm not changing my motion.
Okay. All those in favor say aye.
Aye.
Any opposed? Okay. There you go. Thank you. Moving on to electronic health records. I believe this is Jen.
Yes, this is another thing that we've been talking about at the COA, and in 2017, we issued an RFP for an electronic health record system to get us off of our Access database, which is very challenging, as we were just talking about the client count and information like that. But what we're really looking for was a system that would help streamline the work, that would help us be HIPAA compliant so that we can continue to move forward with serving our clients in the best way possible and promote communication between staff in a streamlined fashion. We received 4 responses to that RFP, and there's a summary sheet included within your packet tonight. And we had a number of staff involved in this process, including staff of IT. We had the team leaders and program supervisors at the Commission on Aging who reviewed the 2 proposals that met our specifications and that were HIPAA compliant. And so there were on-site demonstrations and discussions of those, and that group and team recommended then going with ERSP, which is a software company that met our minimum requirements. And then we did a demo to the entire staff at the Commission on Aging in a couple of meetings. And they, like with other things, are very excited about the opportunity to implement the technology. The one thing about this software package, and I'll be brief, is that, one, it meets our HIPAA compliance requirements. Everything is off-site. It is not housed on our system. If we were to have a standalone system, which was the other one, which was the Carry Vantage program, we would have to have a separate server with encryption, and we currently do not have the capacity in our existing system, in talking with our IT director, to house this program on our system. We wouldn't have any redundancy, and there was no mobile application provided through that provider. So we see some significant advantages to the ERSP program. The user functionality, access through the mobile devices was very clean and very smooth. I think the technology will help us serve our clients better, and I'm asking the board to approve the agreement with the provider tonight.
Do we have a motion?
I will move to approve the contract with ERSP for discussion.
Wait a second.
I'll second.
Moved by Commissioner Wheelock, supported by Commissioner Lathrop. Discussion.
Okay, I guess my first discussion is this billed on a monthly basis?
No, this $10,000 is an annual cost.
Okay, then I don't want to start until January 1st of 2018. I don't want to pay $10,000 to get me from now till January 1st.
No, we would do it on an annual basis from the time of the contract signing. You know, I mean, so
it's not in this, the comment in the editorials here was that it's in the 2017 budget and it's being asked for in the 2018 budget. I don't want to spend the 2017 money today and then have to turn around and spend $10,000 in 2018.
Oh, absolutely not, yeah. It would be prorated for the 2017 months.
So it will be, it will be, basically it'll be prorated back to a monthly fee.
Yes, from the 10,000, so it'd be less.
I guess that's the biggest problem I had when I read the package, so.
Anything else, Bob?
Are they going to be, how responsive are they going to be once this gets loaded to, because you said, like, you put it on a cell phone, I assume, and that kind of stuff. How responsive are they going to be to any problems? We dealt with this on the state level with the veterans' homes, electronic medical records, and it was a nightmare. Just the time it takes to go load into a system and that, and the learning curve is really pretty high. So I don't know how, you know, the health system versus or health records versus medical records, if there's much difference. I would assume this doesn't have as much in-depth information, but I assume that with the portability of it, hopefully it's not something you're sitting there for 10 minutes waiting for the website to load so you can get in there. So I just want to make sure that they're going to be there, and if you say, hey, we're having, you know, it's taking us way too long to do this, what are you going to do about it, that kind of stuff.
It's internet-based on the cloud, so it's not going to pull from that server. And I've been in many situations, I agree with you, it's pulled from a server that's got too much going on with it, it's a nightmare. And people are sitting there unable to work. But that's not going to happen with this. I actually demoed it yesterday, and I have a lot of experience writing and building healthcare records, and I was extremely happy at this particular system and the support that they plan on giving us. They'd already made modifications from the previous demos to change things when they didn't even have a contract or anything. So they suit so many of our needs on different levels, between scheduling the family portal so that family members can sign on and find out what's going on with their family, how they can communicate to the staff, they can see pictures. I mean, I could go on and on and on. It actually also supports our field staff in a different manner. They have a whole separate program for that. So as far as our documentation right now is archaic. And you can't, there's no communication between staff members if someone has to fill in. You have to go back to the office and kind of pull a paper chart, which you can't even read. I mean, this is back in the Stone Ages. We really need to move forward, and it's a great system. I'm really glad that with all their hard work, they chose a system that's really, I think, really going to work for us.
Well, hopefully they'll maintain that relationship. They do a lot of stuff when you're willing to buy, you know.
Honeymoon phase?
Yeah, but hopefully they'll listen to you, and if you see, you know, like to tweak this and that, hopefully they...
It's an ongoing relationship, and I'm actually able to also modify small changes myself.
Okay.
And I'm also able to build an assessment myself, so I can do some of this structure, so we'll get something special that's just for the COA.
Yeah. So
it'll be great.
Very cool.
Sunny?
Okay, the only other question I had, the $10,000 contract, that's fine, I don't have a problem with that. There's a page in here on page 108, it talks about monthly usage pricing. If we have 0 to 200 visits, it's $125. If we have more than 6,000 visits, it's 23 cents per visit. If we have 5,000 to 6,000 visits, that's $1,350 per month. My question is that a fee over and above the $10,000?
No, it's a calculated fee based upon the estimated visits per month. So our IT department took a look at what the activity was, worked with staff to identify the number of visits, and came up with, I believe it's the $5,000 to $6,000 at the $1,350 per month. It might be less than that if I do the math real quick, sorry.
I guess my question has to do is, you know, how many visits per month are we anticipating, and did we get that right? Because we, obviously, last week's conversation, we didn't have the numbers right, and we had to go back in and amend a bunch of...
Yeah, so it's between the $3,000 and the $5,000 number is what the estimate is 3,000 and 5,000 visits number that it's been estimated upon.
The other thing,
Cindy, you have to talk right into the microphone. Sorry.
It's actually impossible to
Thank
run
you.
reports with what we have going on right now. They're not accurate. I mean, I wouldn't even feel comfortable stating any numbers. But going forward with this medical health record, we'll be able to do that. We're going to be running all kinds of reports. So you'll get much better data and know that you're being much better served and that our clients are being much better served. And that our staff is being more productive. And that we're using them more efficiently.
Are any of these fees paid by clients?
No.
No.
So when you look at the standard Medicaid insurance payment form, 10 cents per additional, $2.50 one-time training fee, 10 cents per individual form. The Medicaid is $3.50 training, $1 per claim submitted.
Yeah, we currently don't do that. We haven't had the knowledge or the experience to be able to do that. It's just listed here as a potential fee that if we were to do it, there are a lot of hoops, and I would look to Cindy's expertise in this area as to whether or not we could be able to do that in the future. But it does have the capability to allow that.
Well, it'd be good to know what the value is to doing it. I mean, I appreciate that there's all of these extra things you can do, but if we haven't done them before, do we need to do them in the future?
Well, if we could get a third-party payer to help contribute to the cost of providing to the service to the seniors, we'd be able to leverage those dollars and provide more services to our seniors, potentially at lesser cost. So, I mean, it would be something definitely, if the services we're providing are eligible for reimbursement through the third party, it's something we'd want to look into to maximize those dollars.
Are we currently billing Medicaid for services?
No, sir.
Was kind of my point.
Dan?
I know that I did this about 8 years ago. I went to electronic medical records, and it cost me a lot of money, but I cut my staff from 14 to 7, and now we communicate in the office. I've got 2 offices. They all have the same computer system. I can communicate with Munson or doctors all over the world. It keeps track of who I treat and how I treat and all those things. It's a world of difference compared to the paper method I used in the past.
We don't plan on cutting any staff, but right now we have a big waiting list for all of our services.
Yeah.
We plan on that going away because we'll be much more efficient.
Yeah, but just communicating amongst your staff
Exactly.
about a patient.
Exactly.
You can send a jelly bean over to this, and you can talk to everybody or just one other person without having to pick up the phone, and it's done instantly.
Exactly.
So we're going to have to do this anyway. Why not start with this good group?
Okay. All those in favor say aye.
Aye.
Any opposed? Okay, motion passes. All right, we are going to move on. We have no old business, no new business. Second public comment. Anybody left? Nobody's running for the podium. Okay, Commissioner Department reports. I have a couple. I sent you, everybody, an email, or Chris Kramer sent you an email on my behalf earlier today, that at our November 15th meeting, I will move to rescind the resolution forming the Compensation Commission. We have not had, we've not received the applications required as of today. With budget meetings and holidays approaching, there's no way we can schedule interviews and conduct interviews and seat the commission by the deadline for the state statute was 30 days. So I hope that we can take that matter up after the first of the year again, and we'll talk about it again. So for now, we're going to have to let it lie. So I will move next meeting on November 15th to
And
rescind
Vicki
that.
provided us some pertinent information on that regard earlier this week, too.
So we'll save that and we'll work on it after the first of the year, but I needed to give notice so that we can rescind that. I think November 15th, looks like before that 5:30 meeting, we should have another budget study session, 4 o'clock. See a few nods.
Yes.
Cheryl's not moving, but
You know what
we'll
the
do it anyway.
15th is, right?
I do, but it is what it is.
What's the difference if we're here?
And so we won't know until then about November 29th. I believe Cheryl had something?
I just wanted to ask you about that 15th meeting. If at the conclusion of that board study session, we felt that we were in a position to approve the budget, would we be in a position to do it at that time?
No, we have to have a public hearing. We could
So we could
say
do it
that we're
the
going to
next
have a public hearing. We can't make any decisions at the study session, but we could put it on the agenda for the 15th to move it forward.
In other words, we're not required to drag this sucker out
No.
for 6 more sessions if we don't need to.
Certainly not.
No.
No. That's why we're just doing it kind of one at a time.
In that regular meeting.
Yes.
But we are talking about November 15th, and then the next
Yes.
meeting is December 6th. The
Yes.
one we were already proposing to be the public hearing.
Yes. Okay, so we're right on track. I believe Cheryl had a video to show us, did you?
If Bonnie can cue it up, short and sweet.
Oh, is this our dog video?
It is.
Wow, woof, woof.
This is a Rich Brower production.
No, wait, we're not going to give dogs rides, shall we?
No, we're not going to give dogs bus rides.
They don't have their heads out the window and...
Oh, it's been a long
Bonnie needs her
afternoon.
glasses on.
I do. Can you tell I'm squinting? I don't know why I didn't have them on.
Yeah.
Oh, let's turn it up and start it over.
Don't let your dog be a fugitive from the law. When you license your dog, 100% of the fee helps fund Grand Traverse County Animal Control, which in turn helps everyone, especially lost dogs, who really wish they could find their owner. Don't harbor a fugitive.
Could you run it again and turn the volume up,
I'm
please?
trying to see where's the volume.
Either turn the volume up or just put the microphone down to where it's coming out of the
All
computer.
right, let's get the glasses
That
on.
would work.
There we go. Atta girl.
Yes, that helps.
Watch it again.
No.
Somebody.
No, that's not it.
That's not it.
That's not it, Bonnie. That's not the right video. No, let's stick to what we're
It's not a public service announcement.
Oh, it's all falling apart.
That's one way to control your animal.
Yes.
No, I did not shoot that one.
Thanks to Bob Johnson, that's
Okay.
why we have that one.
There you go.
Okay, just
Volume.
start that one over again with better volume.
Roll it up. That's probably way too
That's
No,
all right.
it's okay.
Don't let your dog be a fugitive from the law. When you license your dog, 100% of the fee helps fund Grand Traverse County Animal Control, which in turn helps everyone, especially lost dogs, who really wish they could find their owner. Don't harbor a fugitive.
Isn't that great?
That's awesome.
Pretty cute, huh?
That's
Yeah,
very good.
very good.
So that's the
Very
public
good.
service announcement that
Thank you, Rich Brower.
and his team put together for animal control for the, at the request of the ad hoc committee, and we'll be shooting that out there. I just wanted to tell you that last dog, that's Lucy, that some of you may remember from the newspaper. Lucy went missing, and she was gone for weeks and weeks and weeks, and she was finally discovered with a broken, somebody found her and she had a broken leg.
Oh.
And she was adopted, and her adopted parent brought her to be a part of our video, so.
Okay, thank you for bringing that. Okay, so that's the awe moment of the day. So we have closed session, right?
We do?
So yes,
Can I
sir.
just make a,
Absolutely, I'm sorry, I was moving on
Just,
before I
if I
asked.
could, in regard to
And then Ron.
notices,
Yeah,
tomorrow night, the local Michigan Townships Association Group and Grand Traverse County Planning will be holding their annual Planning Awards Recognition Dinner. It's at Boone's Long Lake Inn. We're supposed to have RSVP'd last week, so I'm sure if you truly wanted to get there tomorrow night, you could contact Planning Department. I think at Boone's probably won't kick anybody out the door because they didn't RSVP ahead of time. Jean told me earlier that they got like 125 people registered to come, so that's really good. It gives us an opportunity to recognize developers and projects that kind of work toward our master plan and benefit our community. So it's usually a good evening.
and Ron, and then Bob.
Um,
You had another one?
watching the October 18th Board of Commission meeting, there was plenty of talk regarding me, and if anybody has any questions they want to ask me or concerns, go ahead and ask them. Now, I'd like to answer any of them. If not, I'm fine too.
Okay. Or do we want to, we can ruminate on it, can we bring it back on the 15th as well?
Sure. Well,
We're kind of, it's
Yeah.
getting kind of late.
Well,
Okay.
yeah.
Bob?
Just wanted to mention that we've got had a Veterans Ad Hoc Committee was scheduled to meet at 1 o'clock
Friday.
Friday, probably, I don't know
up
if
at
it's here
Lafreniere.
or up in, and we're moving it to Lafreniere
Yes.
at 1 o'clock. The County Veterans Advisory Committee has called a special meeting for 2 o'clock, so that way we can all go to the same meeting, so. Hopefully we'll have time. I can't remember how much time frame. You gotta have 18 hours or something like that for location change or something.
We're within it, it's okay. Yep, okay. All right, so I will move that we go into closed session to discuss trial strategy for Carlson versus Grand Traverse County.
Are we expected to come out with a decision?
Yes.
Well, the event happened November of 2007, so if you think you're going to get a decision tonight, good luck.
Well, we may. We may
I just,
come
in
out and
case
vote on
John wants to
something.
stay, in case anybody wants to stay.
We may come out and vote on
If we have
something,
to
yes.
vote on
So
something.
do we have a second?
Support.
Moved by Commissioner Crawford, supported by Commissioner Klaus. Any discussion? It has to be a roll call to go into closed session.
Wheelock?
Yes, ma'am.
Gorfulet? Mayor?
Yes.
Lathrop?
Yep.
Johnson?
Yes, ma'am.
Klaus?
Yes.
Crawford?
Yes.
5
Okay,
minutes?
we'll be back. I don't know where Chris...
No, I want a 5-minute break. Just want-
Minimal. Hustle on back there.
Hey, surprise.
I don't have my depends on right now.
vote on yet, we still have to. Moved by Commissioner Wheelock, supported by Commissioner Gorfulet. Come out of closed session. Bonnie, roll call vote.
Well, hold on. Gorfulet.
Yes.
Mayor.
Yes.
Lathrop.
Yeah.
Johnson.
Yes.
Klaus.
Yes.
Wheelock.
Yes, ma'am.
Crawford.
Yes.
Motion to adjourn.
No, you don't need that. We're adjourned.
Good.
You don't.
Cool enough.
Have a good night.